Good morning. Are you Burton Edward Bailey?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Excuse me, he will, Your Honor.
Mr. Bailey, in cause number 25 DCCR 1380, you're charged with the state jail felony offense of theft of property with previous convictions, and that's from August 9th of 2025. The indictment alleges you were previously convicted of theft May 13th of 1991, and then again January 11th of 2024, and then August 29th of 2024. And then it further alleges that you were convicted of possession of a controlled substance, a state jail felony, October 2nd of 2008, and after that was final, convicted of possession of a controlled substance, a state jail felony, October 26th of 2011, convicted of delivery of a controlled substance, a state jail felony, May 11th of 2012, convicted of possession of a controlled substance, a state jail felony, October 5th of 2018, and then convicted of possession of a controlled substance, a state jail felony, July 31st of 2024. And how do you plead to that charge?
True.
Well, are you guilty or not guilty of the theft?
Guilty.
Okay, and are all of those prior convictions true that I read out?
Yes.
All right, did you enter your plea of guilty and true freely and voluntarily?
Yes, ma'am.
And did you plead guilty and true because you actually did what they've charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes.
Do you fully understand them?
Yes.
I need to know what some of those prior punishments were. I feel like this is incredibly low for that amount of criminal history.
I'll let you know, Judge, that we took into account, I'm not sure prior with you, but we took into account, and Mr. Rojas can speak to this, the nature of the underlying offense, a theft of clothing and cleaning supplies, Your Honor, from a, I forget the name of the establishment, but nevertheless, to answer the court's question, well, here, I'll just give you this.
Well, let's start with the last one from just July of a year ago, 2024.
77 days on that particular jail charge.
Okay. And then that's the only Jefferson County. We've got some Tarrant County.
In the interest of full disclosure to the court, he does have a 1994 federal conviction for what they term or refer to as take motor vehicle by force. He did 140 months on that. And then on his supervised release, when he was released from that 140 month sentence, his supervised release was revoked to a 10-month sentence. Again, the state's thinking was the underlying nature of it.
No, I understand that. I just, do you know the Tarrant County?
What year was that?
The 18, there's one from 18.
I'll show a POCS from 2018. He did 6 months in jail.
Okay.
Probably state jail.
Yeah, they were all state jail, so it's,
He does have one real felony that did 5 years on. That was back in 1991, Judge. It's an older.
That's right.
okay,
That and the federal case are the only substantial time he's got.
okay. All right, Mr. Bailey, do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Any evidence that Mr. Bailey is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of evading arrest with previous convictions. Find all of those prior offenses true. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I have handed you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you, sir. You can go back with the bailiff. Thank you. Thank you, Mr. Coleman and Mr. Rojas.